All right, now this slide discusses the U.S. Supreme Court agreeing to clarify the law by addressing two court cases. Okay, the first court case was Oswald Owasso Public School versus Favo, which is a mother suing the school district for peer grading. Now, in this case, the mother sued Owasso Public School District for violation of constitutional privacy rights and violation of FERPA after her son's class participated in peer grading system, which I thought was something that all teachers did. Now, when they participated in this peer grading system, I guess her son was called stupid and a dummy for getting low grades on the quizzes. Now, in an effort to protect her son, Favo complained for 18 months and she demanded the district require teachers to either grade student papers themselves or allow students to grade their own. To make a long story short, after the Supreme Court heard this hearing and heard the cases, they basically said that peer editing or peer grading is constitutional or does not apply under FERPA law. So basically, students within the school system can grade each other's papers and use peer editing as a grading system, and it's not considered unconstitutional under FERPA law. So that was the first case regarding peer editing. The second case that I examined was John Doe versus Gonzaga University. Now, this occurred in June 1994 before the peer editing case, and this was a civil rights suit against schools for violation of FERPA. Now, under this one, it was an affidavit denied. Okay, so the Gonzaga case, it was a student known in the court papers as John Doe. He requested from Gonzaga University an affidavit to support his application for teaching certification. Well, the university didn't deny the affidavit based on allegations that the student had a sexual assault. Okay, so basically within this lawsuit, it included a civil rights claim based on federal civil rights law that allows individuals to sue government actors for violation of their rights. So after the student got denied, and they appealed it. The Washington Courts of Appeals reversed the negligent invasion of privacy breach of the contract and civil rights claim. It reprimanded and the defamation claim back to the trial court, from which the jury returned the verdict in the student's favor, awarded him nearly $1.2 million because the affidavit was denied. So these are two court cases under FERPA law. One were FERPA law for the peer grading system. Okay, it was considered constitutional, where peer grading system within the classroom can take place. And the other one was a civil rights case where the affidavit was denied. Basically, the university was considered, they had to reverse the negligence and awarded that student $1.2 million under FERPA law.